put it quite frankly, it was a way of assimilating us into a commercial fishery. There was no talk about the food fishery or for ceremonial purposes or small-scale fishery. This is it. This is how you're going to fish. We're going to get you out on the water. You're going to get so many lobster licenses. You're going to get so much quota. Though Marshall was based on a commercial fishing right, for us it was just so much more than it. It was connected to identity, our whole being, who we were. And we were hoping to introduce a whole traditional approach, but in a modernized or in today's context of bringing back some of the traditional values about the conservation of the resources, the respect for those resources, and what fishing would mean to us. And before we knew it, there was this DFO concept. And yes, it was called a Marshall Agreement or a First Nations Agreement. However, it quickly became apparent to us that this is no different than the DFO regulations.
So we, I guess as a community, talked about that a little bit, and I said, it is part of the whole assimilation process, and that these agreements are at some point, I think, going to be used against us in the court of law. That it will be watering down or defining what our treaty means, what our inherent right means to access to the fisheries. So at the end of the day, it may not be worth anything because they've already paid us.